Hello, this is Matt on the Moon Lambo channel. Although it's certainly true that the SEC has had quite the losing streak in the world of crypto in 2023, the SEC did get a win here at the end of 2023. Here's a headline from Blockworks. Judge sides with SEC in Terraform case on securities sales question. I'm going to let you know the latest and what's going on with this. I have perspective from Ripple's Chief Legal Officer, Stuart Alderati. I've got commentary from attorney Jeremy Hogan, as well as attorney James Murphy, who is known as Meta Lawman on social media platform X. And it's kind of interesting because although some of what is in here is debatable, attorney Murphy actually thinks that an important portion of the decision that was made in this particular case, that Judge Torres, if she were in charge of this ruling, actually would have come to the same conclusion. And it's also interesting because this particular judge who gave the SEC their win here at the end of 2023, he actually argued against Judge Torres, in part, in the SEC v. Ripple case. And I talked about it at the time. And I was kind of dumbfounded by some of the stuff that this guy had to say here. But before going further, I do want to be clear, I do not have a financial background of any kind. I am not offering financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so just to quickly set the table here for a little refresher, here's a headline from CoinDesk, July 31st. So this is just weeks after XRP was declared to not be a security by Judge Torres. And the headline is, Judge rejects Ripple ruling precedent in denying Terraform Labs' motion to dismiss SEC lawsuit. And there's two bullet points. One, a federal judge denied Terraform Labs' motion to dismiss an SEC lawsuit. And number two, and this is the important one, the judge also said he rejected the use of a ruling from another judge who ruled that Ripple did not violate securities law in selling XRP to retail investors through an exchange intermediary. And of course, they're referencing Judge Torres in the SEC v. Ripple case. And it was interesting in particular because once this came out, and we talked about it extensively in the XRP community, I remember noting on my channel specifically that attorney James Murphy, many months prior, I think it may have been 7 months prior, he was warning about this judge actually. He actually called this judge, his name's Judge Rakoff, R-A-K-O-F-F, Jed Rakoff. He named this guy a renegade, actually. And there's a part, I don't want to read this whole article, but here's another article from August 3rd from ZyCrypto titled, No Threat to XRP, Ripple Chief Legal Officer weighs in on Terra ruling. And here you can see James Murphy, a.k.a. Meta Lawman, was also ready to comment on Judge Rakoff's decision. He pointed out that he had called Rakoff a renegade judge in a video 7 months ago. And he just noted that this is a judge that just, for whatever reason, he's kind of known for pushing back against other judges on their particular rulings. It's a pattern for the guy. That's weird because there shouldn't be such a pattern if you're a judge. That's kind of alarming. And so what actually went down? Well, here's the brand new article from Blockworks. Judge sides with SEC in Terraform case on security sales questions. Judge Jed Rakoff, the judge overseeing the U.S. Securities and Exchange Commission's case against Terraform Labs and former CEO Do Kwon, has granted a summary judgment in favor of the regulatory agency. The judgment asserts that both Kwon and Terraform offered and sold unregistered securities. The claim is focused on Luna and Mir tokens, MIR. The SEC argued that Kwon and Terraform offered and effected transactions in unregistered security-based swaps and claims that defendants engaged in fraudulent schemes to lead investors astray. Rakoff wrote that he grants summary judgment for the SEC on count 4 of the amended complaint involving defendants' unregistered offers and sales of Luna and Mir in violation of sections 5A and 5C of the Securities Act. And this is a quote continuing, there is no genuine dispute that UST, that'd be the stablecoin, Luna, Wrapped Luna, and Mir are securities because they are investment contracts, end quote. He further ruled that Howey's definition of an investment contract is a binding statement of the law. Rakoff found that UST, Wrapped Luna, and the aforementioned Luna and Mir are investment contracts under the Howey test. The trial will now focus on the fraud claims that the SEC brought against Terraform and Kwon. The SEC filed its charges in February. And this is a quote here, and this is from Rakoff. Defendants make much of the fact, undisputed by the SEC, that UST on its own was not a security because purchasers understood that its value would remain stable at $1 rather than generate a profit. But beginning in March 2021, holders of UST could deposit their tokens in the Anchor protocol, which defendants' efforts developed and which Kwon himself publicly announced would generate by far the highest stablecoin yield in the market with a target of 20% fixed APR. And so this is, that's the end of the quote. This idea has always been completely ridiculous to me. A stablecoin itself, which is always worth $1, that couldn't possibly in and of itself be a security, right? I mean, remember part of the Howey test, an investment of money, but specifically with the expectation of profit? And so, you can debate this either way, but I think that attorney Jeremy Hogan had a really good point on this. Here, I'll just pull this up now. Jeremy Hogan wrote, "How can a stablecoin be a security? How can you buy something pegged to $1 and expect profit from it?" Per Judge Rakoff in the SEC v. Terraform Labs case, a stablecoin is a security when you can stake it for a return on investment, regardless of whether you do or not. And so think about that. If you have the stablecoin and you're not getting any return on it because you didn't do the thing, you didn't put in the Anchor protocol, it's still a security, Judge Rakoff says. What in the ever-loving hell is that? Does that make any logical sense? Make it make sense. I don't see it. So I'm glad that Attorney Hogan's pointing that out. He also wrote the following and shared this picture of Judge Rakoff. Attorney Hogan wrote, "This is Judge Rakoff, and this is probably an older picture since he is currently 83 years old, same age as my dad. Although if we elect older people to the presidency, we have to trust them with understanding new technology as well, right? Am I being ageist or just a realist?" Yeah, well, I don't think that this guy gets the technology at all. The point's certainly not lost on me. I don't think he sufficiently understands this. Here's Ripple's chief legal officer, Stuart Alderott. He wrote, "I have no firm view on the merits of the Terraform case, but here are a couple of thoughts on yesterday's ruling. Number 1, facts matter. 2, Judge Rakoff does not criticize, let alone even cite, Judge Torres' Ripple ruling." Okay, let's pause note. That is true, but again, as I cited at the outset of the video, he did talk about Judge Torres' ruling over the summer, but not in this final ruling, so fair enough. But this guy's a piece of work. Number 3, the SEC's forever crypto ground war, fighting token by token in lengthy litigation, is a fool's errand driven by a quest for political power over sound policy. Spot on, Stuart Alderott. And here we have perspective from attorney James Murphy, aka Meta Lawman. And here he wrote, and this is just from this morning, SEC v. Terraform Labs. Judge Rakoff's decision actually aligns with Judge Torres' Ripple decision to a significant degree. Judge Rakoff ruled that Luna and Mir were sold as investment contracts to institutional investors by Terra, the issuer, through written agreements. Terra represented that investing in Terra means buying Luna, which is the equity in our company. Quote, "Owning Luna is equivalent to owning a stake in the transaction fees of a network like Visa," end quote. As such, Terra was openly declaring that it was selling investment contracts. Terra sold Mir tokens as yield-generating investments through written agreements. Terra represented that, quote, "profits derived from the use of the Mir protocol are fed back to investors based on the size of their investment," end quote, and, quote, "Mir holders can earn 0.25% from trading fees," end quote. In my opinion, Judge Torres would have ruled the same way on these facts with respect to the Luna and Mir token sales that were offered by Terra directly to institutional buyers by way of written contracts. Judge Rakoff also ruled that the UST stablecoin was sold as an investment contract. He ruled that because UST could be staked on the Anchor protocol, it was a yield-generating investment and hence a security. This ruling is debatable and may be vulnerable on appeal, in my opinion. Yeah, no kidding. I would agree with that. May be vulnerable. I mean, look, I'm not pretending to be an attorney here, but this doesn't make logical sense, right? I think that's why Attorney Hogan pointed out what he pointed out. But anyway, Attorney Murphy continues. "I don't see a material impact from Judge Rakoff's ruling on the SEC v. Coinbase case. Unlike Terra, Coinbase is A, not the issuer of any of the 13 tokens in that case, and B, not alleged to have entered into any contracts with purchasers of the tokens. Caveat, the SEC is likely to argue that Judge Rakoff's ruling on UST supports the idea that A, Any token at issue in Coinbase that can be staked to earn yield should be considered an investment contract, and B, Coinbase's own staking service is an investment contract. As noted, I do think the ruling on the UST stablecoin is debatable. Dollars can be used to earn yield. It happens all day, every day. That doesn't make dollars investment contracts. Right, and so again, not only does it not make it investment contracts, not everybody's even doing it. So come on, you know. And then he names the next part of the thread, the 13 tokens that are issued. They're on screen if you want to read them. I'm not going to read them. But I own a few of those. Not really thrilled that they're getting attacked by the SEC. But then he says the hearing on Coinbase's motion to dismiss is set for January 17th. Remember, not legal advice, just one man's opinion. Happy New Year to all. So we'll see what happens. It actually is plausible that this whole thing gets tossed out. I don't know if it's going to, but I've read perspective and shared it on this channel before that there are attorneys, reputable attorneys, that think that this actually might happen. And if I'm not mistaken, not to put words in Attorney Deaton's mouth, but my recollection anyway, if I'm not mistaken, is that he thought that it was at least plausible that it could happen. So I don't know what he thinks the odds are of it, but my recollection is he said something to that effect. So we'll find out soon enough, just weeks away. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.